Good afternoon again. I'm Yacinto Singwire. I come from Rwanda. I'm the Executive Director of Legacy Advocates. We do a lot of research in consultancies, and recently I've been involved in doing some work with US industry, especially the drone industry, where I have been helping in developing the drone policy and strategy for the government of Rwanda. Thank you.
Good afternoon. My name is Bob Ochieng. I represent ICANN in this panel. ICANN is the Internet Corporation for Assigned Names and Numbers. My background is technical, so you can be assured I know very little about law, but I'm happy to talk to lawyers today and hopefully learn one or two from lawyers at the end of this. So looking forward to the discussion. Thank you.
Ladies and gentlemen, Jambo. Bonjour. Good afternoon. Okay. My name is Claver Nigarura. I am a managing partner of a business law firm in Burundi called Lubeya & Co., member of DLA Piper Africa Group. I'm a lawyer and I'm happy to be here. Thank you, Setudo Hub, for inviting me. Thank you.
Okay, so Clever, as you have the mic, the topic on competition law and regulation of digital platforms is one that maybe we may have difficulty connecting in the room. So could you paint a picture for us on what that means?
Okay, thank you very much. The topic is of interest because when we talk about Africa, we talk about 54 countries. We talk about a population expected to reach 2 billion and above in 2015. So the digital economy and the competition, we have to look at them as Africans. I'm not specialist of all countries, but I have an overview of the competition regimes in different countries in Africa. We have national and regional regimes. I think every country has its competition law. We have competition bodies at the regional levels. Let's take ESA Competition Commission, ECOWAS Competition Commission, CEMAC Competition Commission. To mean that there is a regime at the local and regional level. But the problem we have is like for taxation. These regimes were prepared before this digital era. So the anti-competitive practice we were used to see have evolved. Normally, when you talk about position of dominance, we were looking at the amount of money, the thresholds, but now you have to look at the capacity of gathering data. That aspect is not covered. So in brief, we have competition regimes, but which are not adapted to deal with competition in this digital economy, I have given an example of the access to data. When you have access to data, you have a competitive advantage to competitors. You can use against them. So that is one example. Maybe I may give other examples later. Thank you.
Okay, so Bob, I'd ask you to explain to us what competition looks like in ICANN.
Thank you very much. So maybe I would want to take a step back a bit and bring a few things into perspective. So we're talking about competition, and then we're talking about law, and then we are talking about tech, okay? I'm not sure how many items we are talking about at the same time, but just a mere listing of them, you end up with, very broad, very broad areas. I also wanted us to appreciate the fact that when we talk about tech, or the internet specifically for this matter, are we talking about the same thing? Because I think we need to be on the same page as we approach this topic. So the internet, which doesn't have a standard definition as far as we are concerned, but what we are calling the internet is something that has certain characteristics, which, if all combined, including being open, being, borderless, being free to join, if you combined a certain set of characteristics, then what you end up is the internet. I'm not a lawyer, but I also know that the law has very clear jurisdictions. So when you talk about law governing something, then it applies within, a jurisdiction. So the question is, how do you then talk about law, or how do you implement the law on something that does not have jurisdiction? Because if I asked, what is the jurisdiction of the internet today, so that we put this, laws and how to, have laws on tech into perspective, then you ask ourselves, what is who has jurisdiction over the internet, or which jurisdiction are we talking about? Because the law has jurisdiction, the internet doesn't necessarily. So do we take that into perspective? So that is one. I would want then to give an example from an ICANN perspective. So ICANN's role is to coordinate what we call names and numbers, or internet critical identifiers. I think in the morning we agreed that the first thing we did when we got here was to get your Wi-Fi sorted in. And we've all gone online today. And when you went online, maybe you went to facebook.com or google.com, and you used what we call a name. And if I go to google.com and you do the same, we are supposed to see the same thing. We are supposed to see the same content. Meaning that name is unique, isn't it? That is why we are all seeing the same thing. It's like your number. When we call your number, it is just one number that is supposed to be reached. So we make sure that those identifiers, or names as we call them, are unique, because if they are not unique, then you didn't know which Google is Google actually. So the question is, how do you then apply law onto that? And how do you, for example, deal with competition itself on the namespace from where I sit? So if you wanted to register google.com and it is taken, what is the other alternative that you can do? How do you ensure that there's competition at that level? And how do you, as she talks about dominance, how do you define dominance even at the namespace? So for example, we have .net, .com, .info, .edu. Which one amongst them would we say is dominant? And what would be the criteria of declaring one of them dominant? And is that what our laws do today? Do we have the right criteria within our laws today to define such kinds of dominance? Is that already defined? Are those criteria current, or how old are they? So I think I wanted us to put this into perspective and clarify that, assume you are talking about, a borderless system, and you want to apply law onto it, competition in this matter, and it doesn't have jurisdiction, and our laws have jurisdiction. So how do we balance those two factors? Thank you.
Okay, thank you. So I'll give you an example. In Nairobi, for example, if you're looking to rent a house, you can just say, I want to rent a house, let's say, for example, in Upper Hill, where we are now. And you'll get so many companies that offer you houses in Nairobi. Or they'll tell you this, so X company will come up, Y company will come up, and Z company will come up. So my question is, how do you choose, like for example, how does Google choose which companies or which websites show up at the very top of the Google search, which ones get to the first page, which ones get to the last page? What's the criteria of choosing this companies?
I think you touch on the issue in terms of competition called self-preference for some platforms able to handle competition by giving priority to their own products or services. Yeah, that is a very big issue. And in many laws, you'll not find that this is considered as a anti-competitive practice, because it is done online. It was not there when there is no this digital economy. I think that is also very important to note. Thank you.
Okay, so Yasin, they talk a lot about regulation, and you come from a place where you think we just need political will, and then the regulation would follow. So can you give us an example of your experience?
Yeah, thank you very much. I think Rwanda apparently in the East African community provides an excellent case study of how technology has been embraced, because if you look at how the steps that the government of Rwanda has taken, we cannot really look at them from a legal perspective so far, but mainly from a political will really to fast track technology. We have a number of examples that I have also shared with colleagues, even previously, where we know that, for instance, the government of Rwanda, as in the whole cabinet, district officials, they are not by law, but in practice, they are almost everyone is almost a subscriber to Twitter and Facebook. It has a number of ramifications because of the way it brings into the accountability systems, governance and accountability systems. So basically, we are not seeing this in regulation, but we are seeing that in the context of the politics and how the top leadership has really preferred technology. Part of what other things that we are seeing is how the government of Rwanda has actually initiated some kind of investments where we are seeing the government committing to provide to connect the whole country with fiber optics and actually providing a 4G connectivity fiber optics. So we can imagine, like in the next few years, when the whole country is connected, what that means, especially when we see more other initiatives, such as the challenge. Recently, the president of the Republic of Rwanda initiated a challenge where he was encouraging that every citizen should have a smartphone. Now, that really provides another perspective from a regulatory framework. Where and how are these initiatives going to be regulated? That always brings me to the UAS industry I have always discussed, because I have been involved in developing the policy, where we are seeing Rwanda adopting the use of the drones into services. And apparently we know that Rwanda is delivering blood and other health services through drones. We don't have really a compelling legal framework for that. The initiatives are in place, but we haven't gotten the real legal framework. So there are a number of issues with that. For instance, when we'll talk about right to privacy, privacy regarding the data protection, when we talk about damages maybe that could be caused by these drones, apparently they are not well regulated. But it has not stopped. From a legal perspective, people would have concerns. But again, Rwanda moves fast, always moves into really, when they adopt initiatives such as that, they implement and then they learn through the process. I think it's also fair to comment about how the legal fraternity has embraced technology, where we have integrated, what we call integrated electronic case management systems. We have where cases are registered online. There were some discussions in the morning sessions where people were asking in terms of limits, who accesses data, what type of data that is accessed. And I think the integrated electronic case management systems have some kind of levels of what information can be accessed by what type of persons. For instance, it is restricted boundary where lawyers, prosecutors, as well as the courts have access, but also within that access, there are levels of approvals and accessibilities. So the point I want to emphasize here is that from the discussions, we note that people are very cautious in terms of embracing technology, and especially we have noted that some countries have made reservations with the drones, but we fail to recognize the importance of these technologies. We only know, and most of the people I have engaged in my previous assignments, they tell you that drones are really disastrous. And every time they mention that, they simply relate drones to military operations and maybe issues of privacy, security, and they fail to recognize that drones actually have a number of importances. We talk about health services, as we are noting example in Rwanda. We are talking about precision agriculture, where drones are used in some of the developed countries. We are talking about entertainment, but all these are overshadowed by the perceptions, the wrong negative perceptions of the historical background of the drones. In short, I think that's what I would comment. Thank you.
Okay, so two more questions as we prepare to take one a round of questions and close. So in Kenya, we have the Competition Authority and we have telecommunication companies. And there's been calls and questions on whether we wanted to declare Safaricom a dominant company. And so the national legislation of Kenya conducted a study in which it was to determine what is dominance in communication markets. Until this date, they have been unable to declare Safaricom a dominant company. So that's one consideration. Another example is where Facebook, for example, acquires other subsidiary companies like Instagram and WhatsApp. So there are two types of considerations of how to Safaricom deals is with what Safaricom is doing is something we can quantify. But what let's say, for example, Facebook would be doing at acquiring a startup, for example, which they can project would be valuable in future, would not necessarily be considered when determining whether that company is dominant or not. So do you think our laws are able to envisage both types of situations?
Thank you very much for that question. That question is very relevant because our laws, in terms of measure and acquisition, when controlling the competition, focus on the value of the companies, saying that if this company X buys this company Y, there will be this will affect the market. But for the digital economy, we can think differently. A big company, a big platform may buy a very small at that stage. In terms of money, we do not big value, but it may, by that, to affect the market, to kill competition, to kill innovation, to give advantage to the service or products it is providing. So it's a kind also of anti-competitive practice not covered by our laws. Yeah, I think it is a very important question.
So, Bob, one last question. You talked to us about assigned names and assigned numbers and .org and .com. So what if I wanted, I'm Lawyers Hub and we have lawyershub.org, but we have not registered our website yet and we want to register the website and we find out someone already registered lawyershub.org. What are we supposed to do?
So thank you, and maybe a comment on the last question before I come to that. I mean, in addition to what Clever here says, I think when it comes to the tech space, we really need to contextualize, how we are going to treat the same concept on the different backgrounds. So if you talk about dominance, for example, and you talk about a local company and an international company, if you were asked today whether you trust Facebook, for example, we will give various answers in this room. And if I ask you whether you trust your government, you might also give me various answers. Because it is a very open question. Maybe the right question would be, do you trust your government to collect taxes from you? Then we might have, a better informed answer. Or do you trust Facebook to connect to your friends? Then that context gives you a better answer. So when you say dominance, or when we discuss dominance most of the time, I think our laws are still at a stage, or the laws that we use haven't upgraded to really discuss or consider the actual context of the product or organization or service that we are talking about. We are considering, or the laws considers, competition from a very straitjacket understanding that competition. So you are either dominant because your turnover is this much or not. So maybe we might need to revisit that, and in a kind of a multi-stakeholder way, as we put it in our ecosystem at ICANN, agree on the rules to use on the various contexts when discussing or when we are considering dominance. In the namespace, it's a little bit different in the sense that domain names are more of a monopoly in one sense, because once you are granted the authority to administer a particular domain name, then there can't be any other person being given such a chance. And therefore, the process of identifying whoever gets to administer such a name has to be quite rigorous. As an example, if you hear something called .ke or .tz, you might as well know that that could be Kenya or Tanzania. If it is .com, it doesn't really give a bearing on which country, so it's generic. But how do you decide from Kenya that Kenya's .ke is administered by company A? And who would you say should own .ke? It's like asking who owns +254. So it's a very complicated process to identify that kind of person. That's why the process to do that in our ecosystem is always multi-stakeholder. So we have to let you agree on a consensus that we have all jointly agreed that for us, company X will manage .ke on our behalf. So in a way, that is how to also deal with the perceived dominance at that level, because after that is granted, we assume that everybody else has agreed to live with company X being the manager and then them playing other roles around the same.
Okay, so Yasin, final question. What do you think we need to do to make sure the laws catch up with where competition is going?
I mean, first of all, I think we need to really look at the values that technology provides. Yes, we recognize that there are also some other issues involved, but how have we assessed the value that technology provides? And to do that, it will require efforts from a stakeholders' perspective, where people really understand, and of course, people must be sensitized. People must know the benefits. If it is restricted within the professionals, the technicians, the bureaucrats, the advocates, the policymakers, it may really not generate the value and the attention that it deserves. And again, it goes much as even the professionals. We also see a number of professionals who really don't care, who don't have sufficient knowledge about technology. So it's upon the people who have really taken up this kind of initiative, who understands what technology provides. The lawyers, of course, like we are, these kind of gatherings, of course, makes this, this is a very progressive step in my view of making sure that we really understand what technology is, what it provides, who should be involved. Because, for instance, before I went into technology, I used never to care about anything. For instance, I never used to know that the drones would serve different purposes. I would only... So the moment we get really into this whole discussions, I think the better. And it must not be something that is constrained to only the tech companies or the professionals, engineers. It is a discussion that should be broadened to include other professionals. And I think this is really what is being done here, is one of considering the number and the people, the profiles of people who are participating here. And of course, even outside this framework, it will be one of the best approaches to adopt.